Good afternoon. My name is Matt Ewalt, and I serve Chautauqua Institution as Vice President and Emily and Richard Smucker Chair for Education. It's my pleasure to welcome all of you to this afternoon's lecture by Donald B. Verrilli, former Solicitor General of the United States. Support for this lecture is provided by the Robert H. Jackson Lectureship Fund, which has provided a Chautauqua lecture on the Supreme Court of the United States for the past 15 seasons. Please join me in thanking the Robert H. Jackson Center for making this lecture possible. Introducing Mr. Verrilli will be John Q. Barrett, Professor of Law at St. John's University, where he teaches constitutional law, criminal procedure, and legal history. Professor Barrett has produced extensive scholarship on Robert H. Jackson and serves as the Elizabeth S. Lene Fellow at the Robert H. Jackson Center. He is a graduate of Georgetown University and Harvard Law School. Please join me in welcoming Professor John Q. Barrett back to the Hall of Philosophy to introduce Mr. Verrilli.
Thank you, Matt. Good afternoon, friends. It is always a thrill and a pleasure and, of course, an honor to be back at Chautauqua. In one forum or another, I've been able to lecture here for 19 consecutive summers, and it's really a treasure to be learning with you. Among my different gigs, getting to introduce this lecture is truly a high point, and I'm going to introduce it by touching on three topics. First, Robert Jackson. Second, the lecture, and third, today's lecturer. Robert Jackson, a native of this region, lived from 1892 to 1954, from the Benjamin Harrison administration until 5 months after the Brown versus Board of Education decision that he was a part of. He rose from a farm birth in Spring Creek, Warren County, Pennsylvania, to schooling in Frewsburg, New York, to a law career in Jamestown, New York, and then to national service in the New Deal. He was appointed and then confirmed by the Senate 5 different times to Franklin Roosevelt appointed positions. And the middle of his 5 presidential appointments was the job of Solicitor General of the United States, which I will return to in a minute. In 1941, when Jackson was 49 years old, he was appointed to his 5th and final senatorially confirmed, if you will, presidential appointment, a Supreme Court Justice, Associate Justice seat. After 4 years there, he got another presidential appointment requiring no confirmation, just requiring one to go AWOL and take on a tough job, when Harry Truman sent him to Nuremberg to prosecute the principal surviving Nazi leaders following World War II. Now, in that life of Robert Jackson, I want to pull out 3 particular highlights. First, he was a Chautauquan. He didn't have a lot of high, fancy education. He never went to a day of college in his life. But he, from teenage years, was a regular on these grounds. He heard William Jennings Bryan lecture here in 1908, and as a high school orator and debater, mimicked him thereafter. He began to lecture here during the winter season, which is a little bit of a harrowing concept, in 1915, and continued to lecture at Chautauqua across the rest of his life. He was involved in bringing President Franklin Roosevelt here in 1936 at the request of Jackson's dear friend Arthur Bester, which helped save Chautauqua from bankruptcy because it was a campaign appearance and Roosevelt was followed by Landon and the 2 other leading presidential candidates, and that gate kept Chautauqua in business. A second thread. Across all of his domestic jobs, Robert Jackson most loved being Solicitor General of the United States. He served for 2 years, 1938 and 1939 on the calendar, as Solicitor General, the government's principal advocate in the courts of the United States, handling all appellate matters, and personally and principally handling an enormous load of Supreme Court arguments. And we will return to that responsibility. The third thread is that Robert Jackson is an enduring, powerful legacy in the Supreme Court, in American history, in American law, in Supreme Court decision-making today. And that brings me to my second topic, this lecture. Chautauqua Institution's Robert H. Jackson Lecture on the Supreme Court of the United States is, as Matt mentioned, now in its 15th year. It is an opportunity that Chautauqua Institution creates for Chautauquans to be engaged with leading experts to consider the Supreme Court of the United States at this very sweet spot on the calendar, when the Supreme Court has just risen for its summer recess, and there is new stuff building on a history of enduring important stuff to consider as we look at our Supreme Court. In the past years, this Jackson Lecture has hosted 3 former Solicitors General of the United States: Seth Waxman, who was SG under President Clinton, Paul Clement, who was SG under the second President Bush, and Charles Freed, who was SG under President Reagan. And that brings me to today's lecturer. Today's lecturer, Donald B. Verrilli, Jr., is the 4th former Solicitor General of the United States to be here as Chautauqua Institution's lecturer on the Supreme Court of the United States. Don is a native of Westchester County, New York. He grew up in Connecticut. He attended Yale College and then Yale Law School. Columbia Law School. He then clerked for 2 of the most distinguished judges in American federal judicial history, Judge J. Skelly Wright of the D.C. Circuit and Justice William Brennan of the U.S. Supreme Court, and then went into private law practice, and for a couple of decades was a very distinguished appellate specialist, superstar lawyer in Washington, D.C. And then he entered public service in the Obama administration. He first served in the Justice Department as a Deputy Associate Attorney General, and then moved over to the White House Counsel's Office, and then for 5 years was Solicitor General of the United States for the bulk of President Obama's presidency. That means, to remind you of not very distant events, that Don Verrilli had the point to defend the constitutionality and then in a second round, the legality under a statute of the Affordable Care Act, and won both of those momentous Obamacare cases. That meant he had the point to define and defend the government's fairly complicated legal position with regard to the Defense of Marriage Act, which continued to be enforced but not constitutionally defended under President Obama and then was struck down in the Windsor case, where Don was one of the advocates. It means he participated in and was part of winning the Obergefell case, which brought constitutional recognition to marriage equality under the 14th Amendment. Don left public service in 2016 and since then has been with Munger, Tolles & Olson in Washington, D.C., a leading national law firm where he heads a counseling and appellate practice. He is, across our Solicitors General, I must say, one of the very finest. We're able to listen to those who have argued in the court since 1955 because those audio tapes exist. And we're able to see the track record of their accomplishments. That includes tactical judgment, that includes oral advocacy, it includes receptivity, and it includes, frankly, hard work to sometimes push a big boulder up the hill in the national interest. Our country is very lucky to have lawyers, particularly to have lawyers who are excellent in the position of Solicitor General of the United States. Robert Jackson was one, and Don Verrilli most definitely was another. So my pleasure to introduce Donald Verrilli.
Thank you, John, for that wonderful, wonderful introduction. I think it is the first, I bet it will be the only time in which I am mentioned in the same sentence as Robert Jackson, and I will not forget that. Thank you. And thank you, Matt and John, both for having me here at this wonderful place and to have this opportunity to be with you in this beautiful place on this beautiful day. Really is a gift. So over the past few years, I have found myself using this one particular phrase over and over again. That phrase is on the level, as in, that's not on the level. You know, you can hear me muttering that phrase to myself just about every morning as I drink my coffee and read the newspaper. I use it all the time in my conversations with friends and colleagues as we talk over the events of the day. You really can't be around me for any period of time these days without hearing me use that phrase. And I bet I'm not the only one here that that's true about. I bet I'm not the only one here that that's true about. So this phrase, on the level, is a very common phrase. You all know what it means. Something is on the level if it's honest and straightforward, and something is not on the level if it's dishonest or pretextual. But you might not know the provenance of that phrase. It's really pretty interesting. It actually has its roots in Freemasonry. Freemasons used symbols of stone cutting and carpenter's tools to convey moral truths. And the level was one of the symbols they used. When you're a stonecutter or a carpenter, it's really important that your work be on the level, that it be straight and true all the way across. So something is on the level if it's honest and straightforward. And the Freemasons invested the level with another symbolic meaning, equality. We're all on the same level in the eyes of God and in the eyes of the law. So in addition to capturing the idea of something that is honest and straightforward, this phrase, on the level, also captures the idea that nobody's above the law, that we're a government of laws and not men, in the words that John Adams used in the Massachusetts State Constitution in 1776. And in a democratic society committed to the rule of law, it's vital that the work of the government be on the level in this sense. That's one of those ideas that is so simple and so basic that we take it for granted. But it's really the foundation on which any system of governance that's focused on the consent of the governed, that rests its legitimacy on the consent of the governed, rests. The people need to be able to trust that their government is acting for the reasons it says it's acting. That's how we know that government power is exercised in a lawful manner, that we are a government of laws and not men. Now, every principle has its exceptions. National security or law enforcement may sometimes require government to keep people in the dark. But apart from those narrow exceptions, citizens in a democracy need to have confidence that their government operates on the level. That's true when Congress enacts or amends or repeals a law. It's true when the president and the executive branch adopt or change or enforce a policy. It's true when the president commits our armed forces to conflict abroad. It's true when the government takes actions that might threaten citizens' basic rights. When citizens can no longer have confidence that their government is operating on the level, doing things for the reasons it says it's doing them, the very legitimacy of our system is at risk. Trust dissipates, respect for law frays, as does respect for the norms that form the connective tissue of the law and of our system. People don't know what to believe, so they stop believing in anything. That is dangerous ground for democracy and fertile ground for authoritarianism. So what does all this about on the level have to do with the Supreme Court? Obviously, the idea that our government should operate on the level is not itself a principle of law that the Supreme Court or any other court can enforce. And yet, this idea is at the core of the responsibility that our Constitution assigns to the courts, and particularly to the Supreme Court. The courts make sure that the other branches of government have the constitutional authority to do what they're doing. The courts make sure that Congress and the executive and state and local governments don't violate the rights our Constitution guarantees to individuals. And we have a whole set of legal doctrines and principles in place to ensure that the administrative agencies of our government, the EPAs and the FDAs and the Commerce Department, stay within the law when they make rules to implement statutes that Congress has enacted and when they enforce those rules. Agencies have to be able to demonstrate that their actions are well considered, they're based on evidence and sound reasoning, they're reasonably implemented. So if you really take a step back and think about it, in all of those ways, really what the courts are doing is insisting that government operate on the level. Now, this idea that courts should ensure that government operates on the level is very easy to state in the abstract, and it gets really complicated in practice. We've learned through experience, often hard experience, that we don't want the Supreme Court to be too aggressive in second-guessing the Congress or the President or the states. Congress and the President and state governments are democratically accountable to the people through the electoral process. Supreme Court justices are not. They have life tenure. They're not supposed to be influenced by the popular will. If the Supreme Court demands too much from Congress or the executive or the states, the court ends up supplanting the will of the people with the individual justice's own judgments about policy. That's what happened in the infamous Lochner era of the early 20th century, where the Supreme Court struck down progressive era legislation, both state and federal, laws prohibiting child labor, limiting hours of work per day, etc. And the court, we now see, in retrospect, did so just because it disagreed with the policy judgments that the democratically accountable branches of government made. So some of the Supreme Court's greatest mistakes came when the court took it upon itself to decide what kinds of reasons were sufficient to justify what the majority wanted to do. On the other hand, if the Supreme Court is a rubber stamp, then the judicial power created in Article 3 of our Constitution is no power at all. Our separation of powers framework won't work. And governments, both state and federal, can run roughshod over the rights the Constitution is supposed to guarantee to all of us. If courts are supine, it's basically an invitation to the president and the Congress and the states to get away with whatever they want. Some of the Supreme Court's worst moments have come when the justices blinded themselves to the justifications for government actions that were phony. Take Plessy against Ferguson, a decision from the 1890s that concluded that so-called separate but equal segregation laws did not deny African Americans their 14th Amendment right to equal protection. The argument that legally enforced racial segregation treats blacks and whites equally isn't just wrong, it's transparently not on the level. And yet, only one of the 9 justices who heard that case, Plessy against Ferguson, had the integrity and the courage to call it what it was. So striking that balance is not easy. Generations of legal scholars have spent their careers debating exactly where the balance point lies between avoiding judicial overreach and avoiding judicial abdication. When should courts defer to the majority? When should they assert their power? It's a hard question. And getting that balance right is particularly vexing for the Supreme Court right now, because let's face it, the not on the level quotient of the current administration is uncommonly high, maybe higher than it has ever been in our country's history. And that is putting enormous pressure on the Supreme Court. That pressure is especially acute because the court is not just dealing with the stresses of the present moment, as challenging as they are. It is setting the baseline for the future as well. If the court responds to the current administration by becoming more aggressive, more demanding in its scrutiny than it would in normal times, then it's setting a precedent that would authorize more active judicial superintendents of administrations in the future when things may have returned to normal. It raises the bar that a future administration is going to have to surmount in order for its actions to survive review in the Supreme Court. In other words, it would shift power away from the democratically accountable branches and towards a democratically unaccountable court. But if the court stays its hand when the rationale for the administration action it is reviewing is transparently not on the level, then it lowers the bar. It effectively says to future presidents and future administrations, you don't need to operate on the level. All you need to do is make up some facially neutral explanation for your actions after the fact, and we'll give you a pass, no matter how egregious the action or transparently flimsy the justification for it. The court can remain deferential and hope that things return to normal, but risk that it's actually accelerating a downward spiral. Or the court can be more assertive because it believes that that is what this moment demands, but take a risk that it will result in a long-term shift away from democratic accountability. You see the dilemma. And you can see this exact struggle playing itself out in the Supreme Court's most recent decisions. And I want to talk about 2 of them today. Trump against Hawaii, the so-called travel ban case from a year ago, and Department of Commerce versus New York, the so-called census case decided just last Thursday. I want to talk about those decisions through the prism I just described. But before doing that, I want to set the stage first by talking about one of Justice Jackson's most important opinions, and that is his dissent in the infamous Korematsu case. The cases of the last couple of years are not the first time the Supreme Court has grappled with the question of what to do when the government comes to the Supreme Court to defend a policy that may not be on the level. And Justice Jackson's Korematsu dissent grappled with exactly this problem. How do you ensure that the other branches of government are on the level? And how do you ensure that the Supreme Court does not overstep its limited role in our system? So, Korematsu. Along with Plessy and Dred Scott, Korematsu holds a place as one of the worst, most disgraceful, really, decisions in the Supreme Court's history. In fact, in his decision in the travel ban case, Chief Justice Roberts described Korematsu as gravely wrong the day it was decided and said that it has been overruled in the court of history. I'll come back to that in a little bit. So the Korematsu case came before the Supreme Court in 1944. The Second World War was raging. Here's how the court described the facts of the case in its opinion. Fred Korematsu, an American citizen of Japanese descent, was convicted in a federal court for remaining in San Leandro, California, a military area, contrary to a civilian exclusion order, which directed that after May 9, 1942, all persons of Japanese descent should be excluded from that area. No question was raised as to Korematsu's loyalty to the United States, the court said. The question was whether that exclusion order, frankly and explicitly based on race, violated the Constitution. The government defended it on national security grounds, specifically that it was necessary to round up every person of Japanese descent on the West Coast and herd them into internment camps in order to prevent, quote, espionage and sabotage in an area threatened by Japanese attack, unquote. Supreme Court upheld it. And the opinion was written by no less a champion of civil liberties than Hugo Black. You don't have to read between the lines to feel Hugo Black's acute discomfort. It's right out there in the open on the pages of his opinion for the court in Korematsu. He says at the outset, all legal restrictions which curtail the civil rights of a single racial group are immediately suspect, and courts must subject them to the most rigid scrutiny, and nothing short of apprehension by the proper military authorities of the gravest danger to the public safety can constitutionally justify this kind of race-based exclusion. But Justice Black and the other justices who joined the majority in that case lacked the courage of their convictions. They knew full well that rounding up thousands of Japanese American citizens and putting them in camps for the duration of the war made a mockery of our constitutional values, especially at a moment when we were fighting a war in substantial part to defeat ideologies rooted in racial supremacy. But they weren't willing to challenge the judgment of the military leadership in the middle of an existential struggle with millions of troops deployed overseas. That instinct was so strong that they didn't even require the government to put forward anything other than its word to justify the need for internment. As it turns out, the justifications were spurious. Historians have established that there was no evidence of actual threat of subversion from Japanese Americans in the population at the time, and that actually the government's lawyers knew that when they argued the Korematsu case to the Supreme Court. Whatever the initial justification for this policy, by 1944, the rationales offered for internment orders were not on the level. But the government lawyers put those arguments forward anyway. The court accepted them. Justice Jackson did not. He dissented in an opinion that fused pragmatism and principle. He understood that with the nation at war, it was too much to expect that a court, even the Supreme Court, could stop military commanders from carrying out an order like the one at issue. So he did not try to invalidate the exclusion order in toto. What he did instead was to hold Fred Korematsu's conviction unconstitutional. And that's because he understood something else, and it's that something else that I think speaks to the present moment very profoundly. He understood the lasting damage that would be done by upholding the exclusion order and Mr. Korematsu's conviction. And here's what he said on this point. It's a bit lengthy, but it's really critical, and it speaks to what we're dealing with now, so bear with me here. What Justice Jackson said was, much is said of the danger to liberty from the Army program for deporting and detaining these citizens of Japanese extraction. But a judicial construction of the due process clause that will sustain this order is a far more subtle blow to liberty than the order itself. The military order, however unconstitutional, is not apt to last longer than the military emergency. But once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather, rationalizes the Constitution to show that the Constitution sanctions such an order, the court, for all time, has validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring it forward in a plausible claim of urgent need. Now comes the really critical part. Every repetition embeds that principle more deeply in our law and thinking and expands it to new purposes. A military commander may overstep the bounds of constitutionality, and it is an incident. But if we review and approve, that passing incident becomes the doctrine of the Constitution. There, it has a generative power of its own, and all that it creates will be in its own image. So what's most important about Justice Jackson here is not just his willingness to see clearly and state frankly that the mass internment of U.S. citizens based on nothing more than suspicion arising from their ethnicity violates our Constitution, as important as that is. The deep wisdom here is Justice Jackson's recognition that when the Supreme Court holds a consequential governmental action valid, it's not merely staying neutral. A ruling upholding the government action is a stamp of approval. It's a validation of that action. The court can say all it wants, that it's merely applying the law, it's not passing on the wisdom or judgment of the provision it reviews, but a decision upholding a challenged policy, particularly a consequential one, inevitably confers legitimacy on that policy. And it commits the court, as Justice Jackson said, to a path of upholding similar exercises of government power in the future. So with that frame of reference in mind, provided by Justice Jackson and Korematsu, let's turn to the recent cases. First, Trump against Hawaii. This is the travel ban case. The Supreme Court decided it a year ago. I'm sure the case is all fresh in all of your memories, but just to remind you, here are the facts. About a week after taking office, President Trump issued an executive order banning persons from 7 predominantly Muslim countries from entering the United States. If you want to know what a government action that is not on the level looks like, this is it. Normally, when the executive branch adopts a new policy as consequential as a travel ban, that decision is preceded by serious engagement throughout the executive branch with all the experts and all the departments in the executive getting together, weighing in on the wisdom of the policy, shaping its confines, weighing pros and cons, making these kinds of judgments. But the first travel ban had none of that. It was basically written on the back of an envelope by a couple of guys in the White House who had no national security expertise and no immigration expertise. There was no consultation with the State Department, no consultation with the intelligence community, the Defense Department, and barely any with the Department of Homeland Security. The very parts of the federal government whose responsibility it was to protect national security and secure the borders. And they didn't even try to show that the existing immigration policies were, for screening immigrants from these countries were falling short in creating any unacceptable risk that terrorists were sneaking into the country. And they hadn't thought through at all how to implement the policy. On its face, it barred entry to students and even permanent U.S. residents from these countries. You might remember the chaos that ensued when the policy was first implemented. Now, you could call it the travel ban a solution in search of a problem, but that would be too charitable to the travel ban. Everybody knew what was going on. As a candidate, the president had promised a complete and total ban on Muslims entering the country. The travel ban was a gesture at making good on the xenophobic promise. Now, you might also remember the travel ban prompted a wave of protest. Thousands of people took to the streets and airports. Lawyers by the hundreds volunteered to represent immigrants who were being turned away. Lawsuits were filed across the country, and lower federal courts blocked the ban. Now, the administration could have taken those lower federal court decisions up to the Supreme Court, but they didn't. And I think they had a pretty good sense that they weren't going to get a majority of the court to put its stamp of approval on something that was so glaringly not on the level. So they went back to the drawing board. They put the policy through a couple of more iterations before it got to the Supreme Court. And the version that the court considered banned entry from 7 countries, 5 predominantly Muslim, 2 not, Venezuela and North Korea. It included a waiver provision for individuals from the 7 countries. And the executive branch actually went through something much more like the kind of normal process I described a little while ago, broad consultation with the experts, et cetera. And the administration offered up a facially neutral rationale, essentially that the countries on the list had inadequate procedures for screening and providing U.S. with information about citizens of their countries who were applying for visas to come to our country. So when it came before the court, there were 2 issues, basically. First, was the ban something that the president had the legal authority to do under the immigration laws? And second, was the ban an act of religious discrimination against Muslims? The first of these issues was actually quite a difficult one for the challengers of the ban, because the president just didn't pull the authority for the travel ban out of thin air. or claim an inherent executive power under Article 2 of the Constitution. There is a federal statute that Congress enacted years ago that gives presidents the authority to issue orders temporarily banning any class of aliens from entering the United States, basically for any reason the president thinks is sufficient. The challengers had an argument that the statute shouldn't be read to give the president such broad discretion, but the language did seem to give that discretion, so it was a really tough argument. The real action in the case was about religious discrimination. The administration came forward and said, look, this has nothing to do with bias against Muslims. We've studied our immigration practices. We've identified particular countries that don't provide us with reliable information about their citizens, so it's too risky to let people come into the country from those countries. It obviously isn't directed at Muslims. The vast majority of the world's Muslims live in countries not on the banned lists. There are 2 countries on the banned list that aren't Muslim countries. That was the argument. The basic response of the challengers was, you've got to be kidding. This is a man who, as a candidate, called for a total and complete shutdown of Muslims entering the United States, whose website talked about the great hatred towards Americans by large segments of the Muslim population, a man who claimed that the travel ban was totally fine because, wait for it, FDR did the same thing to the Japanese Americans, and that was upheld. And the president himself described this country-specific travel ban as the way he was going to act on all of those prior commitments. Now, if you put that pattern of statements I just described aside, and that's a really big if, I realize, the government did have a pretty strong case in the travel ban case in Trump against Hawaii. As I said, the president was acting under a statute that gave him broad authority to suspend the entry of any classes of immigrants. Presidents usually get tons of deference from the Supreme Court on matters of national security and foreign relations because the court assumes that the president's got expertise that the court lacks in those areas. Generally, the court assumes good faith on the part of the president in executing the laws. The government's lawyers had put together a facially neutral explanation for the travel ban that seemed on the surface to be rooted in legitimate policy concerns. What made the case hard, though, was the inescapable sense that none of this was on the level. The president's comments were just too numerous, too blunt, too egregious to ignore. The way the policy came into being, as I described earlier, on the back of that envelope, reinforced his suspect character. So this ended up being a really hard case. 5-4 split with the conservative justices joining an opinion by Chief Justice Roberts, the liberal justices dissenting. You can see Chief Justice Roberts struggling with this very issue that we're discussing here today in his opinion in Trump against Hawaii. It's just like Justice Black in Korematsu. It's right there on the surface. The Chief Justice acknowledges many of the president's anti-Muslim statements. He then notes that presidents possess an extraordinary power to speak to fellow citizens on their behalf, and that in our history, presidents have frequently used that power to espouse religious freedom and tolerance. He recognizes that the current president is not exactly doing that. And then he says this, he says, the issue before us is not whether to denounce the statements. It is instead the significance of those statements in reviewing a presidential directive, neutral on its face, addressing a matter within the core of executive responsibility. In doing so, we must consider not only the statements of a particular president, but also the authority of the presidency itself. So there it is. He's saying, look, we understand these statements are terrible. We understand they call the legitimacy of the travel ban into question, but the government has offered us a neutral rationale that we would accept from any other president if these statements had never been made. So if we overturn the travel ban because of the statements, we're departing from our normal rules. If we do that, we diminish the authority of, as the Chief Justice said, the presidency itself, not just now, but in the future. He basically says all this out loud. He basically says, look, I get it. I appreciate that the actions of this president are not normal. But if the Supreme Court responds by raising the bar that the executive's got to meet to clear its actions through the court, then that bar is going to be up too high when we return to normal times. So you can feel the spirit of Justice Jackson's Korematsu opinion hovering all over this. And that's not a surprise, because as I mentioned earlier, the Chief Justice used his opinion in this case to formally overrule Korematsu and consign it to the dustbin of history. And we did that because Justice Sotomayor's dissent accused the majority of repeating the error of Korematsu, of upholding a bigoted policy on the basis of a facially neutral rationale that everyone knew was not on the level. So the justices are clearly thinking about this exact set of problems that Justice Jackson raised in his Korematsu dissent, and very likely thinking about it in exactly the way that Justice Jackson framed it, because they certainly had read his opinion as they were pulling their positions together. As I said, I do think this was a hard case. And you could look at it as an example of the successful use of the judicial power. The original policy was so brazenly not on the level, the federal courts intervened and said, no way. The administration didn't dare take that case to the Supreme Court. It went back to the drawing board, tried to do things the way things should be done, or at least they went through the motions of doing things the way things should be done. They produced a policy justification that looked like the kind of thing a responsible executive branch might do. And so essentially they were domesticated by the operation of the legal process. And once that domesticated version of the policy came before the Supreme Court, the court was in a tough spot to say no to the president on the very first high-profile action of the presidency, and to do so on the ground that the action was not on the level, that it was bigotry, not policy. That would have been a very big step. And yet, the warning from Justice Jackson still hangs in the air, with the majority opinion upholding the travel ban despite these doubts lay around like a loaded weapon, serving as precedent for upholding even more transparently phony justifications for illegitimate presidential action in the future. Now, different people can come honestly to different conclusions about this, but for me, I don't think the changes to the policy and the process that produced them scrub the taint of bigotry from the travel ban, and I don't think that the administration ever showed that we actually had deficiencies in existing policies that required the ban. And it's not like the travel ban was an isolated example of the administration not operating on the level. So there's a real risk in pretending that we live in normal times when we don't. So the court's decision to defer to the president, its bet that the best course through these troubled times is to stick to the normal rules in the hope that we will return to normal times with relatively little damage, really raised the stakes. Which brings us to the census case from last week. Now, the question in that case was whether the administration acted lawfully when it decided to include on the census forms a question about citizenship. Census occurs once every 10 years. The Constitution requires an enumeration of all persons in the country, persons, not citizens, in the words of the Constitution. And it's the job of the Census Bureau, which is part of the Commerce Department, to carry out the census. In the past, the Census Bureau has included questions about citizenship on the census, but in recent decades it has not. And they stopped asking because the question tends to reduce response rates for non-citizen households and for households containing non-citizens. And that results in a significant undercount, and the undercount produces bad consequences. Federal funding is typically allocated by population, so the lower your census population figures, the less federal funding your state gets. Seats in the House of Representatives are allocated by population. So the lower the level of population, the greater the risk that you're going to have a House seat shifted from your state to another one. And that's not all. If the census can produce nationwide citizenship data, then when states and localities draw their legislative maps when they engage in redistricting every 10 years after they get the census data, they can draw districts based on citizen population rather than overall population, and that produces a partisan skew too, moves power in one direction. Now, from his very first days in office, the Commerce Secretary Wilbur Ross was pushing to include the citizenship question on the 2020 census. The problem was that the experts in the Census Bureau thought it was a bad idea, told him it was a bad idea for the reasons I described earlier. It would produce an undercount, and it would undermine one core purpose of doing the census in the first place, to figure out how many persons there are in the country. So Secretary Ross and his aides worked the phones. They tried to get other departments in the executive branch to ask the Commerce Department to gather the citizenship data. And actually, they didn't just work the phones. They did a lot of it in writing and on email, and that would prove to be very significant. They focused particularly on the Justice Department. They called the Justice Department. They said, look, we want you to ask us to gather citizenship data because because you can then say that you need it to enforce the Voting Rights Act more effectively. Now, that got nowhere in the Justice Department. The career employees thought it was ridiculous. Even the political appointees were not interested in doing it. So Secretary Ross called Attorney General Sessions, said what they said on the phone. DOJ then made the request. But it turns out the Commerce Department actually drafted most of the language that was in the DOJ request to the Commerce Department for the information. Something came out later in the litigation. Commerce Department announces that it's going to include a citizenship question. New York and various interest groups immediately go to court and sue. Distinguished federal judge in New York, Jesse Furman, issues an order barring the Commerce Department from including the question. His rationale, basically, this is not on the level. Your own experts in the Census Bureau have told you it will produce a serious undercount. Your real reason for obtaining the information isn't the reason you say. It's not about more effective enforcement of the Voting Rights Act. Now, because time is tight, the case doesn't go through the normal process. It jumps directly to the Supreme Court, and the court hears it on an expedited basis. It's briefed, argued, decided in just a few months, and by a 5-4 vote, in an opinion, as I said, issued just 5 days ago, the court agrees that the Constitution, that the government hasn't justified including the citizenship question. As in the travel ban case, the Chief Justice writes the opinion. Now, he adopts the narrowest possible rationale for invalidating what the Commerce Department did. He says that there's nothing inherently unlawful about including a citizenship question on the census, pointing to the long history of having done it. He says there was nothing inherently arbitrary and capricious about choosing to include it. But, he says, the justification the Commerce Department gave was not on the level. And he almost uses those words. Here's what he says. He says, you know, you've come in here and told us why you asked for this information, why you want the citizenship question on the census, but the evidence tells a story that does not match the explanation the Secretary gave for his decision. The Secretary had said the sole reason was to improve enforcement of the Voting Rights Act. Not true. The Chief Justice acknowledges that review of executive branch action should usually be deferential, but he says, the court is not required to exhibit a naivete from which ordinary citizens are free. The reason that we require administrative agencies to give reasons for their actions, he explains, is to ensure that the agencies offer genuine justifications for important decisions, reasons that can be scrutinized by courts and the public. Accepting contrived reasons would defeat the purpose of the enterprise. If judicial review is to be more than an empty ritual, it must demand something better than the explanation that was offered for the action taken in this case. You can almost hear Justice Jackson up in heaven saying, "Amen." Now, in conclusion, I should tell you that what I'm saying now about the census case is not what I expected to be saying when I prepared this lecture. I had thought going in that this was a case in which the court might invalidate the administration's effort to put citizenship questions on the census, because the record really did suggest that the administration's goals had nothing to do with sound policy, everything to do with political advantage. It was just so obvious that the court couldn't let it go through. And I also thought that a majority of the justices would understand that upholding the administration on the census after it had just upheld it on the travel ban would signal that the court was willing to accept pretty much anything as a justification for presidential action. But I was nervous about whether those initial instincts were right, and the tenor of the oral argument back in April tipped me from optimism to pessimism. As it turns out, though, my initial hope was more in line with reality than my later fear, but just barely. The court's decision in the census case really wasn't a reason to jump for joy. The court rejected the administration's position by the slimmest of margins on the narrowest of judicial grounds. But the decision is a reason to breathe a sigh of relief. Because when faced with clear proof that the government was not operating on the level on a matter of great potential consequence, the Supreme Court last week said no. And the reason it said no was, as I was quoting to you, essentially, This ain't on the level. And I think that's exactly what Justice Jackson would have said about this if we were on the court today. Now, we'll see where we go from here. It was a 5-4 vote, and the court gave the administration room to justify a citizenship question if time permits before the census forms get printed and distributed. But for now, we're okay. And to understand why that's important, consider the alternative. Thank you. Yeah.
Usually go back and forth with the mics.
Okay, questions? Why don't we start over here?
Yeah, thank you. That was a fabulous talk. My question has to do with now with the president saying that he's just going to postpone the census until he gets the answer he wants. Is that something that's feasible? Is that something that he can do? What's the deal?
I don't know what kind of authority the president might have to do that. I haven't tried to figure that out. I don't know whether that's real, whether it's just something that he tweeted out in the face of the embarrassment of losing the case. I don't know. But if he delays it too long, it'll be 2021. And if he's not president in 2021, then he won't decide what's on the census. And so, I wonder whether that's really what's going to happen. So.
Thank you.
Thank you very much for your remarks. You talked about whether the executive is on the level, and I'd appreciate your comments on whether you think the Supreme Court right now is on the level. And just to put that in context, in talking about the Hawaii Muslim ban case, I appreciate from a legal perspective how it might have seemed like a difficult case, but at the same time, had a Obama appointee been put on the court, the 5-4 could have gone another way, and right now we've got a very polarized, politicized bench. So when you have a bench that's so politicized or polarized, pick your term, is the Supreme Court acting on the level?
Yeah, so believe me, I think a lot about what my life as Solicitor General would have been like if Merrick Garland had been on the court instead of Antonin Scalia during my time as SG. I think a lot about that, so I understand your point. But what I'll say about it is, and I think, try to be fair-minded about this, it's hard, it's hard, but I think what you're seeing actually in the Supreme Court is not politics, but politics at one remove. Because I think what you're seeing is that you have justices who are appointed to the court based on their judicial philosophy. And Republicans appoint justices who share a certain judicial philosophy, certain set of norms that they adhere to. Democratic presidents appoint justices to the Supreme Court that have a different judicial philosophy, generally different sentences. And so what you see working out in these cases mostly is judicial philosophy, I think. But and so now that is politics at one remove because it's based on who's appointing them. But I don't think it's naked politics in the sense that they're calculating what's in the best partisan advantage of one party or another and deciding for that reason. I really don't. So I think that that's kind of the fairest thing that's going on. But I will say in that regard, and I think you've got to give the Chief Justice some credit here, is that I think it was true in the census case. I think it was true in the Affordable Care Act case in 2012, that the Chief Justice has some sense that this is not an intellectual exercise where you just think about what your intellectual principles are and apply them as though you were in school, that you're actually exercising the judicial power of the United States, which is a power that the Constitution confers on the executive branch, and the exercise of that power has effects in the world. And I think the Chief Justice decides cases kind of cognizant of that. And so while he votes sometimes in ways that disappoint me, travel ban case being one of them, I think he does some things like NFIB and like the census case that you've got to give the guy credit for.
Thank you.
Your opinion on the gerrymander case?
Don't get me started.
No?
I thought about talking about that case. This is the question about the partisan gerrymandering being something that courts are powerless to deal with. So, we had this fight in our history before. We had it about one person, one vote, and the argument was the courts shouldn't get involved. Courts got involved. They actually managed to come up with judicially administrable standards. We've had the issue of racial gerrymandering, the drawing of legislative districts in a way that disadvantaged people of African American and Latino heritage, and courts have figured out ways to come up with judicially administrable standards. And I thought Justice Kagan did a very powerful and persuasive job of explaining in her dissent why it was possible to come up with judicially administrable standards to deal with this problem too. And I do think this is one of these situations where I wish the court had been more cognizant of the fact that it was doing what I said earlier in response to the question, that it's actually exercising a power of governance. It's not just answering a question in the abstract, because by answering this, this goes to Justice Jackson's point, and it was why I was sort of thinking about, talking about it today, that, you know, the court can say all it wants, well, we're not saying that this kind of extreme partisan gerrymandering is okay. In fact, it's bad. We're just saying it's not our job to fix it. We don't have the tools to fix it. But, you know, you can say that all you want. The problem is that if you uphold it as consistent with the Constitution, you're putting some kind of a stamp of approval on it. You can disavow that all you want, but that's the reality, that the court validates that action. And so I would want to be really, really, really sure that there was no judicially administrable way for the court to deal with it. And I think Justice Kagan quite persuasively showed that there is a judicially administrable way to deal with it. Yeah.
You sort of answered my question, but you led to another one. We have a lot of people thinking about, should judges be originalists or look at the world as it is and deal with those problems. And then you go back to the thought that, well, elections have consequences partly because you get judges based on them. And then you have the gerrymandering question, which gets right down to who gets elected. And it's like, how can the Supreme Court ignore those basic political issues, which in the end makes us America and the democracy?
Yeah. So I'm just going to repeat what I said before. I do think that it's important that they realize that they're exercising a power of government, and that the way they exercise is going to have real consequences. And at a moment where trust in government, trust period, is eroding in our society, and trust in government is eroding enormously, one reason trust in government is eroding is gerrymandering. To say everything's fine is, you know, it's troubling. I mean, it's troubling.
When the Constitution was approved, the average lifespan was mid-40s, and that led to lifetime appointments. Now, among some of the Democratic candidates, there has arisen an idea that the Supreme Court justice lifetime appointment should be changed to a rotation on and off the court for 18 years, for example. What do you think about that, changing the lifetime appointment to something else?
So my friends on the court are not going to like what I'm about to say, but I'm not commenting on the specific policies. I'll talk about that in a minute. The basic idea, I think, of a limited duration of service, 18 years, 15 years, whatever it is, I think that would be a good idea. And the reason I think it would be a good idea is because it would reduce the politicization of the process. Each particular nomination would not be vested with so much political intensity, because you'd know it was for 18 years, and you'd know if you designed the system right, there would be a seat that came up every 2 years, and each president in a term would therefore get 2 appointments, and it would just be a different deal than it is now. And I think that would be healthy, and I think it would take some of the pressure off to appoint people to the Supreme Court while they're still in high school, you know, which is kind of what's happening now. And so for a lot of reasons, I think it'd be a good idea. Some of these particular proposals about, you know, having 5 and 5, pick the other 5, and, you know, I don't know whether that can be enacted by legislation. I haven't really tried to drill down on that, but I have my doubts. I think we may need a constitutional amendment, which would be very hard to get, but the concept is one I think is a good concept.
Thank you.
Hi, I'm a high school AP Government and Politics teacher, and every year I have my students argue 2 upcoming current Supreme Court cases. What are 2 on the horizon that you would recommend checking out?
Oh, for next term, you mean?
For next term.
Okay, so, well, one really good one would be the question of whether the protections in federal law against employment discrimination apply to people, protect people from discrimination based on sexual orientation or transgender status. So I think that would be a really good case to hear. Another significant case the court just took is, although it might be hard in your framework to argue, is about the lawfulness of the current administration's attempt to rescind the DACA program. So, but I think those, at least the first one will be good, the second one might work too.
Great, thank you.
One of the key strengths of our constitutional system is an independent judiciary. You've talked about being on the level. I'd like you to focus on not the Supreme Court, but the 13 courts of appeal, and then I think there's 94 district courts. There's hundreds of judges on those courts who can prevent cases from getting to the Supreme Court. So we have now a situation where we have this leader of the Senate who was, in my opinion, packing the court. How do we get into this situation, and how can we prevent this from happening?
Yeah, you're asking the impossible question there. It's a really hard problem, and I will say, because I don't have an answer to your question, a practical answer, I don't have a practical answer to it, but I will say something that struck me about Supreme Court confirmations, but also the confirmation process for other judges, Court of Appeals judges, district court judges. Doesn't it seem odd that the one thing we never ask in this confirmation process anymore is this person wise? Does this person know how to make good decisions? Does this person have good judgment? It's not about that anymore. It's like, are you in this column over here with this set of preconceived judicial beliefs, or are you on this column over here with this set of preconceived judicial beliefs? And I think it shows you how far we've strayed. Neither side is trying to make the judges political. They're both trying to appoint judges who they believe exhibit the judicial philosophy that they think is right. But at some level, what we've lost is this idea that judges are supposed to be judges, and they're supposed to act wisely, and that those are the kinds of traits we should be looking for principally in judges. But maybe if we had kind of a shift of attitude about that, and we just started thinking about the kinds of people, not that there aren't a lot of wise judges out there, and a lot of judges who've displayed good judgment and act on their good judgments as judges, but that we just seem to value that less now, and that to me is a very troubling thing.
Hi.
Hi.
I just wanted to thank you for your service, Don, and ask when we're going to get to read your book.
Hi, Jess.
Hi. Surprise.
So how are you?
Good. How are you? My mom's here.
Hey, so Jess and I spent 4 glorious weeks together as Rockefeller Foundation Fellows in Bellagio, Italy, where Jess completed her book and I did not complete mine.
And I'm your conscience, and I'm here
Yeah,
to
you
be
are.
the cricket on your shoulder.
Thanks. Do you have a question, Jess?
No, that was it. When will I get to read your book? I'll leave now. You don't have to answer. Hypothetical. Bye.
I love you, Jess.
As already noted in some of your answers to the questions, there are another number of proposals out there to change the composition of the Supreme Court, including expanding the number of justices. My specific question is not about the merits of those, but whether you think that the existence and the possibility of those proposals ever being enacted by whatever means could have an effect on the court, or more specifically the Chief Justice's opinions or decisions as to which cases to take.
So, that's some version of that is what happened in the 1930s, and President Roosevelt proposed his court packing plan, which, had got zero political traction. It really never came close to getting enacted into law. But it kind of raised the stakes quite a bit, and it's impossible to know for sure, but it did tend to coincide with the court's decision that it was going to change direction and be less aggressive about striking down social policy legislation. So there is a historical example out there. History never quite repeats itself, so I don't know that whether it would happen the same way now. I do think that the issue of the court's legitimacy and perceived legitimacy is kind of a front and center issue, and I think it is for the justices. And you can sort of see, not to try to get too partisan about this, but you can see now with some conservative commentators saying, oh, this whole legitimacy thing is baloney. You shouldn't be focusing on that. You should just do what's right under the Constitution and let the public sense of the court take care of itself. And I think the reason for that is because there's an understanding that actually if you factor in the public's perception of whether the court is legitimate, and you're a justice, it's going to tend to make you more moderate. And you're going to tend to not do some of the more extreme things that they're being asked to do. And so, you know, the answer to your question, I think, is maybe. Maybe.
Hello. I have a question whether you know if the status of people with green cards was considered by the justices in their decision, or the people who crafted it, because people with green cards are on a path to citizenship. You know, they could be citizens in a year, 10 years is a long time, and millions of people would become citizens and they wouldn't be counted. So I wondered if you know if that was ever considered, and if not, how would one
Oh, in the census case, you mean? Right.
Pardon?
In the census case, you mean?
In the census case, yeah.
So, you know, I don't know specifically, but if you're counting citizens, you're not counting those people.
That's what I mean.
Right?
But
Now they might answer the question. You know, if the concern with a citizenship question on a census is that if you're an undocumented person, that's when you're really going to be likely not to answer the census, because you're going to be worried that you're going to reveal to the government that you're an undocumented person and they're going to come and get you. If you have a green card, you're probably not in that position because you have a green card, and then they come, they can't just remove you, and so it might make you less concerned about answering the census. So, you know, maybe it's not as much of a problem for that population.
You think they might answer they are citizens if they're not?
No, I think they might answer that they're not citizens, but not be worried that that's going to lead to their removal from the country because they have a green card. So.
But what about counting for funding and redistricting and all that?
They would count, to the extent that the census counts citizens and overall population, all persons too. The problem with asking the citizenship question is that you drive down the overall population number because non-citizens won't respond. So you might drive down the overall population numbers. But I'm not so sure that the green card people would be the reason for that, because I think probably they've got less fear about answering the question. So they probably answer, yeah, I'm here, I'm not a citizen, but I'm a person and I'm here. And so their names would probably get counted on that list. So.
Should Mueller be required, or should he testify in front of Congress? And I'll give you a hint. Judges should not be speaking after they issue an opinion, a written opinion, which would confuse the opinion.
So not my bailiwick, really, not the subject of this lecture. But I think that he wasn't the judge, he was a prosecutor, and that in both the Nixon impeachment proceedings and the Clinton impeachment proceedings, there was a thorough transfer of information from the prosecutor to the House committees that were considering impeachment. And I believe in the Nixon impeachment proceedings that Leon Jaworski, who came in after Archibald Cox was fired, testified several times, I think. And so there's historical precedent for it. And he is going to testify, I think, on July 17th. So.
It's my impression that under the judiciary provisions of the Constitution, the legislature has the authority, the power and the authority to determine the structure of the court, such things as tenure and rotation and that sort of thing. This proposal of limiting the number of years and going into rotation does not open up the court packing problem. So would it stand any chance?
So maybe, I think that the Constitution says that, Article 3 says if you get confirmed as a federal judge, you serve for good behavior without any diminishment of salary. So there's a question of whether that you can continue to serve and not have your salary diminished, but be required to serve on a different court. you know, I'm not sure that that's going to get upheld by the Supreme Court, since they'd be ruling on rotating themselves off the court. And, you know, so I think some of these proposals may work, but some of the more aggressive ones, I'm less confident that they survive the scrutiny of the Constitution.
But there's
even if they're good ideas,
there's a toehold, perhaps, in Article 3.
Now, you're definitely right. The court, there's nothing in the Constitution that says you have to have 9 justices. You can have as many as you want, or as few as you want. The Congress gets to decide it. But you couldn't. I don't think the Congress could say we're going down to 5 and we're going to kick off for the current 9. You know, and here are the 4. I don't think they could do that.
I mean, it started at 5, didn't it?
Okay. Last question.
Does the never-ending fight between trying to legislate through the courts versus legislate through the Congress, does that have any kind of impact upon what you were presenting today? It seems to me that it's just goes on forever. If we can't get it through Congress, we're going to go to the courts. If the courts are blocking it, we're going to go through Congress. Is that still a valid concern?
So that, I mean, that's like 18 lectures on answering that question. Let me just say a couple of points to conclude. So one is that, yeah, you know, a big part of the problem that we have now, I think, it's not the whole problem, but a big part of the problem is that there are issues that Congress has the authority to fix. Immigration is a really good example of that, right? Congress has the authority to pass a law to fix the problem. And if it does so, it's almost certain that the Supreme Court would uphold it. But Congress doesn't act, and therefore presidents, you know, President Obama did it in his way, President Trump's doing it in his way. They feel like, well, you know, Congress isn't dealing with this problem. The American people are not going to accept the answer that the civics book answer that, well, in our tripartite system of government, it's up to the Congress to make the rules, and if the Congress doesn't make the rules, I, as president, don't have the power to do anything about it. You'll never hear a president say that, you know? I mean, they're not going to, because the public won't stand for it. You're the president, do something, you know? And so the Congress doesn't act, the president acts to fill the void. That's challenged as unlawful. It goes to the courts, and it meshes the courts in the middle of all of it. And so it wouldn't solve all problems. If Congress did its job, it would solve some. But there are some issues, and I think marriage equality is a really good example of it, where, you know, that was the debate in marriage equality. Should it be done by the legislature? Should it be done by the courts? Wouldn't it be better if it was done by the legislature? Because then it would have democratic legitimacy behind it, and probably in a perfect world that would be true. But what you're also saying, what you'd be saying to gay and lesbian people in a way similar to what this country said to African Americans for so many decades in the era of segregation, and that Martin Luther King wrote so eloquently about, was, well, you just have to wait. You just have to wait until the majority's ready, and the majority's not ready yet, so you got to wait and still be a second-class citizen. And to me, you know, you can call that legislating from the bench if you want, but when the court says, no, this is too fundamental to who you are as a person, to your right to be an equal citizen of the country, so we're going to act on our constitutional values. No, as I said, you can criticize it as legislating from the bench, but I, for one, am glad when the court exercises its authority that way.
Thank you.
Thanks very much.